Good evening for those who are on Eastern Standard Time. Good afternoon for those on Pacific Standard Time, and good morning for those of us or those of our audience who are in Asia. My name is Diane Desierto. I'm professor of law and global affairs at Notre Dame Law School and at the Keough School of Global Affairs at the University of Notre Dame. For today's webinar, we have the distinct opportunity to discuss ongoing challenges to the rule of law in Southeast Asia. And it is my distinct pleasure to introduce two of the other panelists for today's session. David Cohen is professor of classics and director of the Center for Human Rights and International Justice at Stanford University. He is one of the leading experts in the fields of human rights, international law, and transitional justice, who formerly taught as chaired professor at Berkeley, as well as founding director of the Berkeley War Crimes Studies Center, until he moved to Stanford in 2013 to direct the present Center for Human Rights and International Justice. His research is into war crimes tribunals beginning in the mid-1990s, with a project to collect the records of the national war crimes programs conducted in approximately 20 countries in Europe and Asia after the Second World War. Since 2001, Professor Cohen's work has largely focused on contemporary tribunals and transitional justice initiatives. He has led justice sector reform initiatives and tribunal monitoring programs, specifically in Southeast Asia and Indonesia, East Timor, in Cambodia, and also in countries such as Sierra Leone, Bangladesh, and Rwanda. In Southeast Asia, he has worked closely with the ASEAN Secretariat and the USAID Technical Facility to the ASEAN Secretariat, informing and leading an expert group to create a human rights resource center for ASEAN. David is also, we intersected as former colleagues at the University of Hawaii Richardson School of Law, and it has been a pleasure to collaborate with him in co-editing this book. Our second panelist today is a dear friend, a distinguished colleague from the National University of Singapore Law School, who is adjunct professor specializing in constitutional and administrative law, international law, and international human rights. Professor Kevin Tan is also editor-in-chief of the Asian Journal of Comparative Law. He is an extremely well-known academic with professorships at the National University of Singapore, as well as at the Rajaratnam School of International Studies at Nanyang Technological University, where he also teaches constitutional law, international law, and international human rights law. As a very distinguished constitutional law and international law scholar, he has published widely in his areas of specialization, and having written and edited over 40 books on the law, history, and politics of Singapore, with very well-known editions, which are very numerous to mention at this rate. I would highly recommend taking a look at his institutional webpage to see the body of work, and particularly pertaining to Southeast Asia, Malaysia, and Singapore's constitutional system. He has been and continues to be on the editorial board of various leading legal journals. He was chief editor of the Singapore Journal of International and Comparative Law, and from 2000 to 2003 was the journal's adjunct editor. He is currently editor-in-chief of the Asian Yearbook of International Law, executive editor of the Asian Journal of Comparative Law, and editorial board member of the Korean Journal of International and Comparative Law. He also serves on the board of governors of the Human Rights Resource Center in Southeast Asia. Welcome, Kevin, and welcome, David. It is a pleasure to engage with both of you tonight, or I should say this morning. Good morning to Kevin in Singapore. Let me turn over to David, who will start off our book discussion with an introduction of the topics that we will cover.
Thank you very much, Diane. First of all, let me thank you and your colleagues who have done all the work to organize this event. Very much appreciated. And also, it's an honor to share a panel with two such distinguished colleagues as Professor Desierto and Professor Tan, both of whom I have known and worked with for many years. And it's out of the discussions that we've had over the years that the idea for this book emerged. And specifically, as Professor Desierto mentioned, we were colleagues at the University of Hawaii Law School for several years, and frequently engaged in discussions about what was happening in ASEAN at this formative period where ASEAN had, from the beginning of 2009, for the first time taken on a legal identity by the adoption of a charter, and then a few years later launched a process of ASEAN economic integration. And as Professor Desierto and I discussed the many initiatives that were going on in ASEAN as part of that move towards greater economic integration and the various challenges that ASEAN faced, we expanded that discussion and, of course, turned to my colleague and friend, Professor Kevin Tan. As we thought about both what was going on in ASEAN and what was understood outside of ASEAN on that process, the idea of doing this book emerged. There were certainly work being done on ASEAN economic integration, but what we saw was missing from the scholarly dialogue were discussions of where the law, and particularly the rule of law, were being left as various initiatives towards economic integration proceeded apace. And there seemed to us to be a gap to be filled there, and that was really the beginning of this book. And then utilizing the very broad network of connections that Professor Desierto and Professor Tan have in the region, we brought together a group of, I think, experts from the region who have a very wide range of experience in various aspects of ASEAN law, but also the way in which the challenges in ASEAN law have emerged, particularly in regard to the rule of law, human rights, legal harmonization, and the implementation of the commitments that ASEAN has made that that economic integration should operate to the benefit of all the citizens of ASEAN. And I think as anyone who reads the book and hopefully participates in this meeting will see, in order to fulfill that promise to the peoples of ASEAN, upholding the rule of law is an essential part of the process of economic development and integration. And it was towards that end that we published this book, and I'm sure that these issues will inform our discussion today. Thank you.
Thank you very much, David. We turn now to Professor Kevin Tan, who will discuss initially for about 10 to 12 minutes his vantage point on the rule of law, but also on the nature of ASEAN law. And perhaps, Kevin, to invite you as well in discussing your contribution to think about the current recurring issues regarding challenges to the rule of law in Southeast Asia. We know especially that in 2021, ASEAN has surprisingly been all over the news, in particular with the UN Security Council asking or requesting ASEAN to deeply take charge of the ongoing democratization crisis and human rights crisis in Myanmar. And perhaps with that, we can begin with your intervention.
Thank you very much, Diane. And it's a great pleasure to be here on the panel with you and David. It's been a long time. We've known each other and worked with each other for a very long time. But I think this is really the first time we've actually sat around a table, literally together. So thank you very much for having organized this. As a prelude to what I'm going to talk about, let me maybe begin by going a little bit back in time and looking at the origins of ASEAN. And I think one of the big problems that observers have about ASEAN is that they think that ASEAN is a regional organization, and it kind of should look like a regional organization like most others, like the European Union, for example, or if you look at South America, if you look at Mercosur and so on. And people seem to think that, well, ASEAN should look like that or is somehow like that, but ASEAN isn't. ASEAN grew out of a very, very difficult period in Southeast Asia, um, leading up to the creation of the Federation of Malaysia in 1963. And as a result of this, what happened was that Indonesia, the most important and the largest country in Southeast Asia, decided to launch an unofficial war, what they call the confrontation or confrontasi, against the formation of Malaysia, which they characterize as a neo-colonist plot, right? The basic idea being that the British, in creating the Federation of Malaysia, wanted to maintain its dominance in the region. This, of course, led to a major falling out between Malaysia and Indonesia. And of course, armed conflict. We had, even in Singapore, saboteurs being sent here to bomb, important government installations and so on. In any case, what happened following the fall of President Sukarno was that Tanat Koman, the then foreign minister of Thailand, decided to try and heal the rift between these two countries, particularly Malaysia and Indonesia, and bringing in the Philippines as well. And of course, the Philippines was part of this very hostile situation because there was this idea that maybe there might be a major federation of states in Southeast Asia at that point in time, with Indonesia and Philippines in the lead, called Malfalindo. In any case, that was what happened. So they was trying to, in Bangkok, try and stitch things together. And it was then that the five ASEAN states, by then Singapore was already independent from the Federation of Malaysia, and they decided that they would form an organization which they called ASEAN. So in 1967, there was a meeting in Bangkok. They issued something called the Bangkok Declaration, and you had ASEAN. The idea behind that was that it was to form uh, an institution that was a regional uh, uh, institution for cooperation among the states, and would be open to all member states. And of course, it was only in the 1990s that they admitted other states. But the original ASEAN countries were five, right? There was a Malaysia, Singapore, Philippines, Indonesia, and Thailand. The idea behind the ASEAN Charter, behind the Bangkok Declaration, was not supranational. They never had the idea that any of these countries would be surrendering an iota of their sovereignty towards some kind of a supranational organization. So it was not in the same way that, say, the European Union came together, where you wanted to create a supranational body. This was never on the cards with the ASEAN 5, and unfortunately doesn't really remains largely the case with modern ASEAN even till today. So if you're looking for ASEAN as a sort of to have a powerful secretary general, then you would be looking in the wrong place. As our friend David, I know him very well, Ambassador Ong Keng Yong of Singapore, who was once ASEAN Secretary General, once told me, when I congratulated him on being made ASEAN Secretary General, he said, "Oh well, Kevin, you must understand, I really am much more Secretary than General." And so, ASEAN is not designed, was never designed as that supranational body. In fact, the one shocking revelation I had was that the budget of the ASEAN Secretariat in Jakarta is actually smaller than that of my law school. So that's something very telling. You can't run a supranational organization with that kind of a budget. So with that, maybe I'll just pivot very quickly into what I was trying to say in my chapter in this book, because the book title speaks of ASEAN law, and I took upon the task of trying to deconstruct this meaning of what ASEAN law was about. I mean, you can talk about EU law. That's easy, right? There is that body of law. There are huge textbooks on what EU law is. But if you will say ASEAN law, you're going to have a big problem trying to define what it is. So what I tried to do is to unpack this problematic phrase and drill down into, breaking it up into seeing what ASEAN law might be about. One of the biggest problems with trying to find out what ASEAN, so-called ASEAN law is that there is no authoritative source. ASEAN Secretary General, Secretariat has issued something like 81 documents on their website, which they call, key documents. But that's not everything. The most comprehensive database actually sits at my university at the Center for International Law at NUS. And there we have over 1,000 documents on various agreements that have been entered into by the ASEAN states, inter se, as well as by ASEAN with other entities. So if you look at ASEAN law, you have a large chunk of bilateral or multilateral agreements between various states in ASEAN. It could be bilateral, then tons of bilateral agreements. Uh, those are like any other bilateral agreements enforced under normal treaty law. You have a number of multilateral agreements that also is pretty much under general treaty law, because they do not kind of involve the status of ASEAN. And I forgot to mention that it took 41 years between 1967 and 2008 before ASEAN had a real legal personality. And for the longest time, when we all talked about ASEAN, you had no idea whether or not ASEAN could sue or be sued in its own legal capacity. And the answer was no, it didn't. And that's why in the ASEAN Charter, it was finally sort of made legal. 41 years after its birth, it finally got its birth certificate, an official legal one. So, so if you're looking at ASEAN type agreements, you would have to look at agreements that were made generally after 2008. Very clearly, ASEAN had those capacity. But again, there were a number of agreements that were made before ASEAN Charter came along, and then you had that body of law, and you couldn't just throw that out because they did have legal impact as well. So, to cut a long story short, trying to find out what ASEAN law is a major problem. And I sort of broke them up into various types. There's, of course, the ASEAN laws between states themselves. There are treaties between ASEAN as an entity and other non-ASEAN parties. It could be individual states like the US, or it could be also other organizations. And so I try to understand what is the status of those particular treaties. And what I found is that generally, while it may be made in the name of ASEAN, most of these treaties actually are, in a sense, jointly made by the relevant states concerned. So the states are always named in these treaties, and then it would be put in some kind of a parenthesis made in the capacity of ASEAN. Uh, this is usually indicative of the trying to show ASEAN solidarity, but in essence, if you look at those treaties carefully, they are actually multilateral treaties between, say, 5 states in ASEAN and the external party. So again, ASEAN itself doesn't have a very strong legal presence in that sense. There is also no treaty monitoring. I mean, one of the things about treaties is that you need treaty monitoring. There is no treaty monitoring mechanism. Many of the treaties that are signed by the states of ASEAN among themselves as ASEAN also tend not to be terribly enforceable. They tend to be aspirational in nature. And so, I suppose that's why it was thought that, you don't really need some kind of a treaty mechanism. But this is something which we find highly problematic. And finally, in terms of dispute resolution, of course, with treaties, okay, let's say you don't have a treaty monitoring, but invariably there will be disputes that arise out of treaties. So the question then is, how do you resolve these disputes? And there isn't well, there is a formalized mechanism insofar as economic disputes is concerned. A framework was put in place, but that has never ever been used at all. In fact, there was one instance where a dispute arose, which could have been resolved under the ASEAN treaty, the dispute resolution process, but instead went to the WTO dispute resolution process instead. So there seems to be a great reluctance by the states of ASEAN to in a way be legalistic. They talk a lot about rules-based systems, but rules prove to be rather inconvenient most of the time. So that's maybe a good starting point for us to for me to say a little bit about what Diane asked me about, which is the ongoing crisis in ASEAN and in Southeast Asia. Well, as you can see, ASEAN is not a supranational organization. It cannot take collective action in a way that many regional organizations may be able to do. A lot of the work within ASEAN is done on a very, very closed door diplomatic basis rather than on a legal front, right? So nobody is going to go out there and tell Myanmar, look here, you signed these various conventions. How can you do this? Nobody's going to do that. What happens is that the ASEAN ministers would meet and they would find ways to persuade, cajole uh, Myanmar into doing something that they would like them to do. So this is the big problem with ASEAN, right? So I think sometimes people expect too much out of ASEAN. There is only that much that ASEAN as a body, as an institution can do. If you look at the ASEAN Charter, you will find that the language is designed to preserve individual state sovereignty more tightly than anything else. Interference is frowned upon, and everything is supposed to be done sort of in the ASEAN way, which is becoming highly problematic, right? Which is that you try to get consensus rather than confrontation, and you try and get everybody to agree. Well, obviously, it's difficult to get everybody to agree if one of the parties decides that they don't want to play by the rules. I think I should pause there and then give you back the floor, and then we can pick up this discussion maybe later.
Thank you very much, Kevin. Certainly, I think there's going to be a lot of questions following up on what ASEAN is expected to do or can do in relation to the democratization crisis in Myanmar, which is an intersection of humanitarian crises with forced displacements, with the use of force, with human rights violations, with ongoing issues even regarding credentials and who can represent Myanmar at the ASEAN summit. So definitely we will pick this up after all the preliminary interventions. May I now invite David to discuss for his first 12 minutes. David, I think you're still muted.
Okay.
That's perfect. Thank you.
Yeah. So thank you very much, Diane, and thank you also, Kevin, for providing me with a very convenient lead-in to some of the issues that I wanted to discuss. So as Professor Tan told us, from 2009 forward, after the adoption of the charter in late 2008, ASEAN, for the first time, had a legal personality and legal obligations under the charter. ASEAN, and Professor Tan already mentioned this phrase, began talking about a rules-based community in ASEAN. And I think it's noteworthy that the phrase rules-based community tended to displace the phrase the rule of law. We don't need to go into a very academic discussion of the distinction between the two, but there are, I think, important distinctions. But if ASEAN now is a rules-based community under a charter, and if that charter, as it does, has provisions that commit ASEAN to fundamental principles of the rule of law, human rights, and democracy, good governance, et cetera, where are we in implementation of those commitments? And both Professor Tan and Professor Desierto have already mentioned Myanmar, and certainly Myanmar calls into question those commitments. But Myanmar is not the only state that does. Thailand has had its own constitutional crisis, and in substance, though no longer in name, is ruled by a military junta that rewrote the Thai constitution to ensure that they could remain in power under the pretense of democracy. ASEAN was largely silent on that. If we look at Cambodia, there has been greatly increased authoritarian crackdown by the Hun Sen regime over the past 3 to 4 years. The main opposition party was doing too well, so it was dissolved. And the leaders of the party and most of the parliamentarians have been charged with treason, along with other civil society leaders. There's a trial of 61 of them pending in Phnom Penh on charges of treason, of trying to violently overthrow Cambodia, which I can assure you they had no capability whatsoever of doing. ASEAN has largely been silent on all of those issues in Cambodia. In the Philippines, as is well known, there has been major issues of extrajudicial killings in relation to the war on drugs launched by President Duterte. There are other issues in the Philippines as well. What has ASEAN done on those? We could go on. There's been a constitutional crisis in Malaysia, et cetera. There is a separatist movement in Papua, in Indonesia, that is a continuing source of sort of low level but continuing violence and alleged human rights abuses. So all in all, although Myanmar is a convenient focal point and a very important one for considering where ASEAN is in terms of its political will to make the principles of the charter more than paper promises. I'd say since the charter, the clock has gone backwards rather than forward. And that is ironic that having now had a charter with those guarantees, in many ways, the situation is worse than it was before the charter. There is, however, I think, a hopeful sign, I use that term guardedly, in the sense that some of the ASEAN member states have, to a significant degree, broken with ASEAN tradition and criticized Myanmar in harsh terms publicly, both through the ASEAN Intergovernmental Human Rights Commission, not the commission itself, where consensus is impossible on this issue, but 4 of the members, commissioners, made an independent statement. And we've also had very strong statements from the Prime Minister and the Foreign Minister of Singapore, from Malaysia, from Indonesia, et cetera. So that brings me to the second point that I would like to discuss, is to what extent does the willingness of states like Thailand, Malaysia, Indonesia, and Singapore to break with the tradition of non-criticism, criticism being taken as interference, and so forth, does that represent a growing fracture in ASEAN, or the potential for a fracture? And I think that beyond Myanmar, ASEAN is at a critical point in its development, and whether or not the traditional ASEAN way of doing business by consensus is really sustainable. And that's because, in addition to Myanmar, ASEAN faces a number of other challenges that divide it. Those challenges both involve ASEAN relations with China and with other neighbors. And I'm referring to the issues on the lower Mekong and the South China Sea. The operation of 11 Chinese major hydroelectric dams within China, as well as further dams financed and built by China in Lao PDR, one is on hold in Cambodia, have already caused and increasingly are causing environmental devastation for the Mekong countries, reverse salinization in the Mekong Delta, the virtual shrinking of the Tonle Sap, one of the largest freshwater lakes in Southeast Asia and major source of protein for a very large percentage of the Cambodian population. At least 120 million people depend upon the Mekong for their livelihoods in Southeast Asia, and those livelihoods are under threat now. However, what is ASEAN doing about that? Well, Chinese influence, particularly in Cambodia and Lao PDR, 2 of the 5 Mekong countries, is impeding there. What about the South China Sea? ASEAN has still not been able to achieve a code of conduct in the South China Sea, despite 20-some years of negotiation with China. There's been a recent flare-up with the Philippines. There's ongoing issues with the other island groups, the Spratlys, and so forth. And again, you have a group of ASEAN member states for whom the South China Sea is critically important, and a group for whom it's not. And the consensus rule has consistently inhibited ASEAN from taking a strong stand on the South China Sea, on the Mekong, or on similar challenges as we're seeing today in Myanmar, and in regard to the ASEAN policy on Myanmar and the continuing toleration of human rights abuses, not just with the coup, but going back, as Professor Desierto mentioned, to the expulsion of 1 million Rohingya, accompanied by murder, torture, and sexual violence on a massive scale. And another significant expulsion, although less publicized, which concerns groups like the Kachin, the Shan, and so forth in Myanmar. So where is ASEAN going to go? I think that's, if I had a crystal ball, I'd be happy to tell you, but I can't because we don't know and ASEAN doesn't know. And that is not a very welcome situation for ASEAN, given the gravity of the challenges that it is today confronting that really directly address the issue of ASEAN unity and the ASEAN way. Thank you.
Thank you very much, David, and thank you very much, Kevin, for those interventions. For my part, I'd like to focus on 3 points, especially in regard to the book's discussion on development and how ASEAN sees this pillar of development, which is also a cross-pillar issue between the ASEAN economic community, the ASEAN political security community, and the ASEAN sociocultural community. Drawing from the narrative and the discussion of both Professors Tan and Cohen, one might think that the ASEAN that seems to be reported regularly in the mainstream media as a definitive organization with certain powers, one would think that this is all fiction. But I would temper this position somewhat and call it, my first point, call it a paradox of pragmatism. What we see taking place within the bureaucracy in the first place, also depending on the mobilization of the ASEAN chair. I mean, so much of the work of producing the agreements, the day-to-day coordination in the Association of Southeast Asian Nations also is inspired by the chairmanship, who holds the chairmanship of ASEAN, which rotates every year between the 10 ASEAN member states. And to the extent that the chair has an agenda setting power, which is largely unacknowledged by outsiders to the ASEAN organization, the chairmanship is influential in putting key problems and issues on ASEAN's agenda. I used to wonder myself as a Southeast Asia scholar how it is or how it could have been even possible for something like the Charter of the Association of Southeast Asian Nations to be passed, especially with its sweeping commitments back in 2008, sweeping commitments to the rule of law, to democracy, to human rights, to international law, international humanitarian law, all in the purposes and principles of the Charter of the Association of Southeast Asians. And beyond that, also a commitment, a stated commitment on the part of Southeast Asian nations that they would take all necessary measures, the key provision in the ASEAN Charter, Article 5, where ASEAN member states committed to take all necessary measures to implement ASEAN law, the decisions of ASEAN as an organization. This brings in what Professor Tan was pointing out, the difficulty of locating sources of ASEAN law is certainly one that compounds and renders somewhat fairly complex what should be an easier task of coordination after 50 years of existence. But we have to remember that before ASEAN's charter was passed around 2008, 2009, before that period, there were almost 41 years of agreements, communiques, commitments that were made year to year in every chairmanship of ASEAN, which under the charter of the under the ASEAN Charter were continued and given continued legal validity under the present charter-based ASEAN. So even trying to hunt that up is almost like an archaeological challenge. At the same time, the continued normativity is fairly perplexing. One would think that an organization that doesn't have this much of a budget, that to a certain extent is very much driven by the chairmanship of ASEAN and which country holds it, that to a large extent has very entrenched ASEAN traditions in terms of the ASEAN way and building consensus. One would be surprised at the volume of environmental agreements, of economic agreements, of agreements on the movement of persons, on the proliferation of normativity at the treaty level, as well as in softer instruments, to which in the day-to-day operations of the ASEAN Economic Community, at least are being implemented, albeit not being perfectly monitored. So what I see here is a paradox of pragmatism. While there is a conscious sense of Southeast Asia's entrenched culture drawing from its history, its entrenched culture of refusing to embarrass or humiliate or criticize fellow members in Southeast Asia. Recent events, as indicated by Professor Cohen, are startling for any ASEAN observer. The fact that there is an increased willingness on the part of newer generations of ASEAN bureaucrats that are willing to speak up on issues is something that suggests perhaps that notwithstanding old ASEAN traditions, the continued normativity of ASEAN is also giving some basis for certain members of Southeast Asia to speak up, to propose solutions, to try to act on a regional basis. This takes me to my second point. There is an increased, and I see this paradox of pragmatism as in much the same way as Professor Cohen describes it, as an inevitability to have a political as well as an economic and socio-cultural resolution, a cross-pillar collaboration on regional issues, which is what we focused on in this book. In many of the books on the great scholarship involving ASEAN, you will find very specific targeted approaches to looking at aspects of the economic community and how trade and investment and how finance is facilitated, among others. We did not replicate what is already a very rich scholarship. The gap that we saw was in examining the cross-pillar issues for ASEAN, because this is also the hub of where, at least on my end as well, and where David and I were discussing this years ago, where we find increasingly regional issues will implicate not just one pillar community, not just the ASEAN Economic Community, it's also not just the ASEAN political security community, and also not just the ASEAN sociocultural community. As David has mentioned, territorial and maritime claims, particularly in the Southeast Asian region, that has predominantly been referred to in the ASEAN Maritime Forum, but that also has economic dimensions, very serious economic dimensions when we're talking about the bidding out of concession blocks for petroleum exploration, for hydrocarbon exploration. There's also regional issues in its bid to transition to renewable energy sources, which is also a regional issue which hasn't been discussed at the same cross-pillar effort, or at least that has been done for other issues. The issue of maritime security is definitely of serious concern to this predominantly maritime region, which has one of the biggest waterways and busiest waterways in the world. And we're not just talking about the high-profile activities of China's maritime militia in Southeast Asian waters, because that's very well documented, very well known. But there's also activities involving human trafficking, involving drug trafficking, involving various maritime security threats to Southeast Asia, which at this point also call for sociocultural responses, as well as political security responses, as well as economic responses. And yet, what we're seeing and what we're observing year to year from every chairmanship of ASEAN is that much as individual bureaucrats in these meetings in the different communities will agree that there should be cross-pillar collaboration and cross-pillar coordination. The initiative to do that cross-pillar collaboration or coordination is not exactly, has not been hammered out, notwithstanding 51 years, 51 years of its existence already, and its own institutional culture among ASEAN bureaucrats. Apart from this, and I know we've talked a lot about Myanmar, there are ongoing refugees and internally displaced people's issues in the movement of persons within Southeast Asia. There is a considerable variance, especially when we talk about the business and human rights space, which ordinarily would be considered as an economic community issue with possibly a sociocultural community issues. And yet we see that in these particular spaces where there are variances between jurisdictions on labor protections, on the right to work and just and favorable conditions of work, the right to organize and the right to represent one's workers within any particular private sector entity, one finds that the economic community, much as it internalizes so much of the references to the International Labor Organization standards, references to international human rights law, much of the initiative is taking place at the level of individual initiatives towards, say, corporate social responsibility. There isn't a top-down regional institutional effort, and our colleague and contributor Michelle Staggs Kelsall discussed in her chapter in this book on business and human rights, how this is very much driven by civil society organizations in ASEAN and not necessarily by the governments that have already committed to implement human rights treaties to which they are already a party. And probably something a little bit closer to home is when COVID-19 struck the world, and when it struck Southeast Asia in particular, a country, or rather a region with tremendous diversity in income capacities. Singapore and Brunei Darussalam, of course, are extremely wealthy countries. Indonesia has wealthy natural resources right up there with Malaysia. But when we talk about that, and as regards CMLV, the Cambodia, Myanmar, Laos, Vietnam countries, the Philippines, Thailand, among others, there were variable responses to what the region could do in regard to both economic responses, but also the coordination of healthcare responses in this region, especially given the infectious nature of COVID-19 and the fact that there were variable policies on the ground as to how far lockdowns could go. The Philippines, for example, is one of those regions that has had some of the longest and most severe lockdowns, but there being very little space or opportunity for Southeast Asia to coordinate even amongst them with respect to travel restrictions, with respect to healthcare responses. And that's largely a reflection of how the pandemic and the kind of new era that is ushered for the rest of the world, how that has also challenged the notion of cooperation. And at least in my view, for the second point, my view is the proliferation of increasingly regional issues inevitably will push ASEAN to the point that it should have to choose, that it has to choose. Which brings me to my last point. When we started out writing this book, initially we thought we could write on different aspects of rules involving ASEAN, which actually has been very well done by many other scholars. One of the things that I was seriously questioning was the understanding of development. Among the usages that are very frequent in ASEAN documents and ASEAN treaties, instruments, and agreements, apart from rule of law, there's always a reference to development. The creation of this bloc was supposed to be in one way or the other, beginning with the Bangkok Declaration to the very latest ministerial documents from the head of summit, supposed to be for the development of Southeast Asia. Howsoever that changed and shifted in understanding over time for Southeast Asian politicians and governments that were in power. The question today is, where does ASEAN stand on how it perceives its own development, and in particular, what it is prepared to do on a regional basis to achieve this development. The enterprise behind constructing this coordination, collaboration, this platform of the ASEAN way that eventually gained its own legal personality was supposed to be also, in one way or the other, from every treaty and every document, targeted towards a vision of development for Southeast Asians. And Southeast Asia, in and of itself, is an extremely diverse region, linguistically, religiously, culturally diverse region. It is not as readily transposable as, say, the European Union project, where there is a vision of what is Europe. But the question here is, what is the vision of Southeast Asia? And where is that vision of development? And to that extent, how does Southeast Asia, through ASEAN, engage its constituencies in the decisions that are being made supposedly on behalf of ASEAN and its peoples? I'll close with an example. Before this pandemic, ASEAN had a master plan for connectivity, which is partly similar to the Belt and Road Initiative. Some of those projects are basically overlapping with China Belt and Road Initiative projects. The goal was to promote more land-based and sea-based connectivity between Southeast Asian nations through massive simultaneous infrastructure projects. And yet, notwithstanding this master plan for connectivity, where many partners, external partners of ASEAN have signed up, there has not yet been, to date, a concerted effort to identify what the common standards will be for the development of these projects in individual ASEAN nations. Will there be environmental and social protection in these projects? Will there be public participation and transparency in regard to these projects? Will there even be a consideration of how local communities view development? Is it necessarily the proliferation of land reclamation-based large-scale infrastructure housing facilities, or is it something else? And to what extent are Southeast Asian peoples, because this is supposed to be a people-centered ASEAN, to what extent are the Southeast Asian peoples actually engaged in the process of discovering what development actually means for Southeast Asia? I will close here and open for discussion among the panelists. For those who have questions, please feel free to send them either through the chat. But in the meantime, I'm going to invite David as well as Kevin for their comments on one issue that I do want to start with, because we all see commonly that there are growing fractures in ASEAN. Probably a basic question: can ASEAN last? Can ASEAN last under the weight of so much diversity, under the weight of so much increasing challenges? Can it still be relevant? Kevin?
Thanks, Diane. Well, like David said, I wish I had a crystal ball. I can't tell. But I think let's look at it from the perspective of relative interest. If you do a kind of cost benefit analysis, ASEAN, the reasons for keeping ASEAN together are that ASEAN on an international stage acquires a prominence that individual states may not acquire. In other words, if you hunt in packs, a huge pack like this, you are likely to gain attention of relevant notables around the world. So if you need to meet, the American Secretary of State for some matter or other, then I think it's much easier if you went there as ASEAN, a block of 10, than if you went there as a small state, Singapore. That's one. So that those are that is the major benefit on an international stage. There is, of course, the economic side of things, where because of so much trade that actually occurs in the intra ASEAN region, the lifting of tariffs and so on are beneficial all round. They do benefit ASEAN. So my qualified answer would be that ASEAN will last, but maybe not in the form that was envisaged by the eminent persons groups and a high-level panel in the 2008 ASEAN Charter.
Thank you, Kevin. We have a question from Sean King at Notre Dame. Professor John, do ASEAN nations ever act as an informal ad hoc bloc within global organizations like the UN and the WTO?
I imagine they do. I'm afraid I don't have insider information on how these things operate at these levels. They tend to be, negotiations that take place with government officials. So I imagine that they do. I mean, generally speaking, ASEAN, where economic interests are concerned, do coalesce quite readily, actually, in these kinds of negotiations. It is where issues involving ASEAN states within and between themselves uh, that create friction. I think that's the big problem, right? I mean, I'm quite happy to join forces with my neighbor if we have a common enemy somewhere else. But if we can't agree, A, on who that common enemy is, that's one, or B, worse still, you and I have a big fight within the region, or I have an internal fight within the region, and some external forces are hoping to influence how that fight goes. Well, that's when uh, this regionalized moment is going to collapse.
Thank you, Kevin. Professor Cohen, in addition to my question, there's also a question from Sean King. How important is Phnom Penh to Beijing as an ASEAN consensus spoiler, especially as it regards the South China Sea?
Uh,
I think you're still muted.
Yeah, I thought they were going to unmute us. Anyway, so we can look at what happened when, during the ASEAN summit in Vientiane, ASEAN leaders negotiated until very late into the night and came up with what was apparently, well, actually it was leaked, a reasonably strong position on the South China Sea. And before it was released to the press early the next morning, Cambodia reversed its vote. And what resulted was a very watered down version. I don't know, but it may not be coincidental that 2 weeks later, another huge tranche of Chinese foreign assistance was received by Cambodia. In conversations that I've had with some ASEAN diplomats who I will not name, what they've said is, well, China has 2 votes in ASEAN, and that's Cambodia and Lao PDR. So that's more than enough to stop consensus. And I think it will not help matters that China has been defending Myanmar at the UN and in other forums. So if this junta stays in power, then we're likely to see Myanmar moving in that direction as well.
Thank you very much, David. And also in answering a question also from Sean, and the question is addressed to me, and because President Biden has talked of hosting a summit for democracy, which ASEAN states might we expect him to invite. I would fairly expect the invitation would be extended to everybody within the Southeast Asian bloc. And in particular, the Biden administration is trying to, at least on the optics of it, if not in the reality of it, trying to rekindle its alliances with countries in the region, and in particular with hosting a summit for democracy, providing a gentle reminder of our commitments to democracy in the region. Thailand and the Philippines have historically been strong allies of the United States. It's an open question whether the governments of both states will see this Summit for Democracy as an opportunity for the renewal of alliances. We have 1 minute remaining, and I think we just reached the 9 p.m. cutoff for this highly interesting webinar. Let me just leave this at this point and thank our panelists, Professor Cohen, Professor Tan, as well as the Liu Institute for Asia and Asian Studies at the Keough School of Global Affairs at the University of Notre Dame for the opportunity to have this engaging book discussion. And for those of you who are attending live tonight and those who are going to view later, view the recording of this discussion later, perhaps I will ask for just one brief comment or sentence from each, from Professor Cohen as well as from Professor Tan, as a parting thought or a parting shot.
My parting shot, Diane, is to thank you for organizing this event and for the staff at the Keough School and your colleagues for having organized it so well. And it's been great to participate. Thank you.
Well, let me join David in expressing my thanks for this, but my one parting shot in relation to the subject would be that for those of you who are watching ASEAN from afar, I think it's too early to give up on ASEAN yet. I think a lot is going on in the region. There are those of us who work here who are hopeful that things can get better, even if they may perhaps get worse before that happens. So stay tuned. We do live in interesting times. Thank
and
you.
on that note, thank you to Professor Tan, Professor Cohen. Thank you as well to the Liu Institute for Asia and Asian Studies, the Keough School of Global Affairs, and the University of Notre Dame. My name is Professor Diane Desierto at Notre Dame Law School and the Keough School of Global Affairs. A good day and a good evening to everybody.